Committee is going to come to order. Chair reminds the committee that when we finished opening statements yesterday that we are on H.R. 5. The bill is open for amendment at any point. In keeping with the chair's announced policies from January, I will first recognize the sponsors of any bipartisan amendments. Are there any such amendments to be offered? Seeing none, the bill is open for amendment. Who seeks to offer an amendment? The gentlelady from Wisconsin.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the title of the amendment.
I may make an argument that's bipartisan, but it isn't currently.
I'm sorry, what?
An amendment by Ms. Baldwin of Wisconsin.
Without objection, the amendment will be considered as read, and the gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. If there's one consistent message I've heard loudly and clearly from my colleagues on the other side of the aisle, it's that the federal government should not impose its will on states or intrude in states' rights. Well, Mr. Chairman, this is precisely what the underlying bill would do. Medical malpractice liability is governed by state law, but H.R. 5 would preempt most state laws and impose a federal mandate on medical malpractice liability. And this is an intrusion on states' rights. It interferes with a state's ability to oversee its own citizens and its own affairs. And a change in policy that I suspect violates the principles of many who serve in this body and on this committee. My amendment is simple. It would protect a state's right to maintain authority over its medical malpractice or medical product liability cases. The amendment states the following: nothing in this act shall be construed to modify or preempt any substantive or procedural state law governing medical malpractice or medical product liability cases, or to impair state authority regarding legal standards or procedures used in medical malpractice or medical product liability cases, end quote. This language may sound familiar to some who serve on this panel. That is because it is 100% identical to the language in Section 2, Subsection C of H.R. 816, the Provider Shield Act of 2011, another bill relating to medical malpractice and medical product liability cases. The bill that I'm referring to was drafted and sponsored by Dr. Gingrey and co-sponsored by other members of this committee, including Dr. Burgess and Mr. Murphy. In that way, I would argue that it's mildly bipartisan, although I do not have their co-sponsorship at this moment. I would assume that my colleagues included this critical language in their bill because they understand the importance of ensuring that states maintain the right to establish a method to handle medical malpractice cases that best suit each state's needs. And I'm sure that Dr. Gingrey, Dr. Burgess, and Dr. Murphy understand that what works best for a state like Wisconsin might not work well in Georgia, Texas, or Pennsylvania. Rather, each state should maintain the authority to determine what works best without federal intrusion. Yesterday in my opening statement, I talked a little bit about my own state, and I'd like to share, since there's greater attendance today, a little bit more about what is working in my state and why I think it's important to maintain Wisconsin's right to maintain its own medical malpractice policies without federal preemption. Since the 1970s, Wisconsin has maintained a medical malpractice policy that has produced successful outcomes for both doctors and patients. With the flexibility to think creatively, Wisconsin established a system in which health professionals are guaranteed access to affordable medical liability coverage, and injured patients and their families are guaranteed to receive reasonable monetary relief for their injuries. Wisconsin law requires physicians, hospitals, and other professionals to have medical liability insurance. This private health insurance pays claims of up to $1 million for each claim arising from an occurrence in a calendar year, or up to $3 million for all claims arising from all occurrences in a year. For medical malpractice claims that exceed the limits of primary medical liability insurance coverage, all physicians have access to something in Wisconsin called the Injured Patients and Families Compensation Funds. Physicians contribute to this fund on an annual basis. Notably, this fund typically makes more money in interest than it pays to injured patients in any given year. As of June 30, 2010, the Patients and Families Compensation Fund in Wisconsin had assets of $855.1 million. And Mr. Chairman, Wisconsin's medical malpractice laws have produced successful outcomes. Medical liability insurance premiums paid by Wisconsin doctors have been nearly the lowest in the nation, and the number of medical negligence cases has decreased significantly since this fabric of laws were enacted in our state. The number of people per year who have been compensated for injuries or death caused by physician negligence have been nearly the lowest per capita in the nation, and Wisconsin medical malpractice insurers have the lowest loss ratio of all states' medical malpractice insurers. But it's important to note that Wisconsin's medical malpractice laws are a solution that seem to be working really well for Wisconsin. They may not work in Georgia, they may not work in Texas or Pennsylvania, but this system works in my home state of Wisconsin. I would assume that my colleagues would agree that states like Wisconsin should have authority to do what works best, but the federal government should not come in and tell Texas, Georgia, Pennsylvania that they have to adopt Wisconsin's system. My amendment and the language from which it is plucked in H.R. 816 would allow each state to maintain the authority to determine what works best for their state without federal intrusion. I urge my colleagues to stand up for states' rights and support my amendment, and I thank you, Mr. Chairman, for the time and yield back the balance.
Gentleman's time has expired. Gentleman from Georgia, Dr. Gingrey.
Mr. Chairman, thank you, and I respectfully rise in opposition to the Baldwin amendment. Ms. Baldwin describes what has been done in Wisconsin, and I think that medical liability reform law goes back to 1975. In fact, if you look at it, if you look at every provision, not just the Patient Injury and Family Compensation Fund, which, by the way, I applaud in the Wisconsin law, although a former governor or former governors of the state of Wisconsin have tried to raid that fund several times, and one time successfully, to spend money on other expenses. I don't know whether it's education or public safety or whatever, but I do commend the law that was enacted in Wisconsin in 1975. H.R. 5 is legislation which has a provision, Section 11. We'll talk about that, I'm sure, today in the markup. But it gives states the ability particularly in regard to their caps. If they've set caps on punitive that are higher than the $250,000 provision in H.R. 5, or if they have set caps on non-economic pain and suffering that are higher than $250,000 in H.R. 5, or indeed lower, those caps prevail. So we respect the state's rights to do their own thing if they have addressed the situation, such as they've done in Wisconsin and California and Texas and Florida and West Virginia and many other states. Now, the gentlewoman referenced my bill that in regard to the Provider Shield Act, suggesting maybe that it's somewhat of a dichotomy that we would want doctors, medical providers to have protection, but what the Obamacare law, PPACA, Patient Protection Affordable Care Act, does or potentially can do by so many of its provisions. I could go through and list a number of them, Mr. Chairman. Section 207, 2701, 2702, 3001, 3002, just go on and on and on in regard to provision in PPACA that could add causes of action against healthcare providers. In regard to H.R. 5, nothing in this legislation, which in fact is very, very similar to what was done in Wisconsin, allows for additional causes of action. And so I think while the gentlewoman from Wisconsin is well intended in regard to her amendment, and certainly in her description of the good things that were done in the state of Wisconsin, her amendment, in effect, would just negate the beneficial aspects of the federal law, H.R. 5, that would be applicable to states that haven't addressed the caps on non-economic or punitive. And that's really one of the most significant aspects that cause the $62 billion over 10-year additional cost in the healthcare system. So with that, I will be happy to yield time to any of my other colleagues, or Mr. Chairman, I'll yield back the balance of my time.
Gentleman yields back. Are there other members wishing to speak on the amendment? Gentlelady from California. I'm sorry, Colorado.
Thank you, Mr. Chairman. Actually, though, this bill preempts almost every provision of state laws, because what it does is it preempts the all state law, including joint and several liability, availability of damages, attorney's fees, and periodic payments. While it does leave in place some state damage caps on economic, non-economic, or punitive damages, it puts the caps in the bill on other states that have decided not to do limitations on damages, including states whose limitations were struck down as unconstitutional by state Supreme Courts. So some states would then have their damage caps, but also be forced to accept federal cap mandates, which would undermine the work of the state legislatures. And let me give you an example of California, Mr. Chairman, since you mentioned California. The microcap in California only applies to non-economic damage claims against medical providers, so California would keep that cap, but then it would also cap punitive damages as well as non-economic damages against the pharmaceutical, nursing home, and insurance industries. And one of my concerns with this bill over the years has always been that tort law, particularly with respect to medical malpractice and other types of issues like that, has always been a state issue. And so state legislatures and state courts have always set forth what the laws are going to be in those states. And I think if you set up a whole new federal cause of action, it would not only solve the problems that doctors are having with their medical malpractice insurance rates and all of that, it would also be and maybe some people think this is a good idea, it would be a boon for lawyers, because it would set up a whole separate federal cause of action on what have traditionally been state tort claims. And so I think that it's confusing, and I think it's an additional layer of litigation that may not be intended by the proponents of this legislation, but would be a very, very real byproduct. And with that, I'd be happy to yield to anyone on my side who would care to comment. Mr. Waxman, I'll yield to Mr. Waxman.
Thank you for yielding to me. This has always been a state's issue. The states license the doctors. I think the Medical Association would be crazy if we wanted to go crazy if we try to license doctors and all the other health professionals at the federal level. This is a state responsibility. Tort laws are state laws. Insurance laws are state laws. In California, where everyone speaks so highly of MICRA, MICRA has been successful in holding down insurance costs, but the evidence is very slim, if non-existent, when we look at the possibility of holding down services that are unnecessary, or defensive medicine. But the reason California's law has been successful in holding down insurance rates is that California adopted, by ballot proposal, where we adopt so much of our law, a regulation of the insurance industry. We rely a great deal on the states, and even though California is held up as a model, there was an article within this last week that indicated with all the budget cuts, the state law policing doctors has been unable to police doctors in irregular activities. They license them, and when they're licensed, they should follow them. If they're continually involved in malpractice or wrongdoing, we expect the Board of Medical Quality to review the doctor's continuing licensure. Well, they can't do it at the state level. And you can imagine what it would be like if we moved it to the federal level. But Mr. Gingrey, I think, is incorrect when he says that the bill allows states to pass their own laws. It only allows the states to pass laws that are more helpful to doctors and other healthcare providers. The provision says on page 25, this act shall not preempt or supersede any state or federal law that imposes greater procedural or substantive protections for healthcare providers and healthcare organizations from liability, loss, or damages. And then it goes on to say in the next section, no provision of this act shall be construed to preempt those state laws where they are more helpful to the providers. But nothing would allow the states to do something where they think it's more appropriate to be more pro-consumer. So if there's a preemption, that ought to just be a preemption. And in fact, that's what this amendment by our colleague from Wisconsin would accomplish. Let the states enact their own laws. Let's see what works, and let other states follow the successes of what some states are doing, or work their own will for their own unique state problems. Thank you for yielding to me.
The chair would recognize Mr. Barton.
I want to rise in opposition to the amendment. And I'm going to yield to Dr. Gingrey and the gentleman from Kentucky. But let me say this. It's nice to know that the ranking member and the author of the amendment are now born-again states' rights advocates. In the last Congress, they were fine with preempting states by requiring a mandate that everybody in the country had to have insurance, and mandating the coverage that had to be provided, and mandating the cost and the actual benefits in those coverage. They were fine with that, but when we come along and offer an amendment to try to bring some national rationalization to medical malpractice, they seem to lose their ardor for a federal preemption. I mean, the point, in fact, of gentlelady's amendment is it would gut the bill. And there's no reason for the bill if you accept her amendment. So I would hope that we would oppose it. I wanted to yield to Mr. Whitfield for 2 minutes, and then obviously yield to Dr.
Thank you very much. I would just make the comment that we certainly have the right to be involved in this kind of issue from a federal standpoint because of the financial impact that Medicaid, Medicare have on our health care costs. And it's been suggested that we would save about $210 billion a year in cost of the national health care system with this legislation. One other comment I would make, there are lots of states like Kentucky that do not have medical malpractice reform. And what's happening to us is we're losing doctors because they're all running across state lines, like to Indiana, where they do have medical malpractice reform. So I think our bill will strengthen our system, save money, and it certainly does not prevent a person from going after full economic damages. And if you look at some of the awards in California, patients are being taken care of, because I'm looking at awards here of $84 million, $59 million, $12 million, $27 million. So I don't think that this legislation would take away any protections for patients. Thank you.
I would yield to Dr. Gingrey the balance of my time.
I appreciate the former chairman and the gentleman from Kentucky for yielding to me. At first, Mr. Chairman, I'd like to address a question to council. One of the members on the other side mentioned that H.R. 5 would cause additional causes of action from a federal perspective. Council, can you give us an answer to that? Is that a correct statement, or is that an incorrect statement? It would not. Let me make sure that my colleagues on both sides of the aisle heard the response of council. It would not create additional causes of action from the federal perspective because of the enactment of H.R. 5. Former Democratic chairman of the committee, now ranking member from California, said, let's see what works. you know, don't rush to judgment. Well, we have had medical liability reform, tort reform in an existence, and yes, the state of Wisconsin, certainly the state of California. The senior senator from the state of California would agree that MICRA, Medical Injury Compensation Reform Act, that was passed in the late 70s in California, is working, and it was not because of any ballot initiative. It was because of a law passed in the state of California. What works is 35 years of experience from California and now some other states, not to $50 million in PAPACA that could be awarded to certain states to start pilot projects over the next 5 years. We've waited long enough. We don't need another pilot project. We have the studies, and it's time to act. It was also mentioned that this is all about protecting doctors and what's in it for the poor plaintiff. Well, if you can eliminate all these frivolous lawsuits, those people who are actually injured and deserve their redress of grievances, their full redress of grievances, without the bulk of a settlement or judgment by an award by a jury going to plaintiffs' attorneys, but rather than to the injured plaintiffs themselves. So we certainly do not take away any of that to right to their redress of grievances, and I yield back.
Gentleman's time has expired. Ranking member of the committee, Mr. Waxman, is recognized for 5 minutes.
Mr. Chairman, I didn't say, and I think the gentleman misunderstood if he thought I said, that this increases the number of causes of action. What this bill does is sets in place a law for all 50 states that no single state has. This isn't the micro law for California. The micro law only limits non-economic damages to $250,000 medical malpractice against health care providers such as doctors or nurses. This bill goes way beyond that for medical device manufacturers, pharmaceutical companies, insurance companies, HMOs. The micro only applies to professional negligence. Now this bill would say that even if there's an intentional tort, imagine a doctor or health care provider assaulting or raping a practice, that would have a limit on pain and suffering. The loss of a spouse is different. The cap on punitive damages are not capped in California. If you put this bill together, it's telling all the states, you may have different parts of the law, but now you got to take all of them. Because Washington is telling you what you need to do, not your own constituents. Now, we just heard the argument a minute ago that we need this law because of the high costs of expenditures for health care. Well, of course, high costs for expenditures for health care affect federal expenditures, but they affect the states and the private sector as well. I don't know what would work best in Wisconsin or Texas or Louisiana or anywhere else, and I don't think they ought to tell us what we ought to have in California. California is quite capable of making up its own decision, and it decided that in addition to the micro law, they would have insurance reform. No, most states don't have the insurance reform provisions that we have in California. So I just want to clarify the record. This is not micro. This is not what Wisconsin has. This is not what any other state has. This is something that is non-existent in any state. And the states, if they want to choose these options, they should do it, but we shouldn't force them to do it. That's exactly what this bill, in fact, does. Now, let me say a word or two about the medical liability system. It's a crummy system. A patient that's injured by malpractice, now that we're not guaranteeing outcomes, but a patient who's injured by malpractice or negligence on the part of a professional should be redressed, their grievances. But if they can't afford a lawyer, they're not going to get into court. If their case is too small, they aren't going to find anybody to help bring their case. If they can't afford it, they're not going to be able to pay a lawyer to pursue it. Most of these cases are on contingency fees. In other words, they get a doctor to represent them, on the basis that if they win, they'll get a doctor will be paid. If they lose, the doctor will not be paid. Well, that's appealing to patients who feel they have a claim, but can't afford to pay pay a lawyer by the hour. Now, these contingency fees are troubling because doctors sometimes come out with huge judgments, and in fact, lawyers will come out with huge judgments, and that means the lawyers will often take the cases only where they expect to get a huge judgment. Well, if you've been injured and your injuries are not substantial enough to justify a huge judgment, probably a lawyer won't take your case. That seems to me the real reason for the cap on pain and suffering. Because when you put on a cap on pain and suffering, it's not fair to the patient who, let's say, is going to be deformed and in pain every single day for the rest of his or her life. The cap on pain and suffering serves the purpose of making the case unattractive for lawyers to take on a contingency fee. Well, that may be a great accomplishment. There are frivolous cases that are taken, but there are real cases that will not be pursued. So it seems to me that if we wanted to do something about the medical malpractice situation, this kind of a bill is not the answer. The answer ought to be something that we think through together, and that the President has hinted that would try to compensate those who are injured and protect doctors from frivolous lawsuits, perhaps with a protection if certain standards in the law are met by the professional. But this is a system that's going to be imposed on the states, and I don't think it's a fair one to anybody concerned, and the ones who lose out are the ones who have been injured. They lose out the most.
Gentleman's time has expired. Members on the Republican side, Mr. Bilbray.
Thank you, Mr. Chairman. Mr. Chairman, I listened to this conversation and just want to point out some of us that have actually provided the safety net for health care to the working class. I spent 10 years supervising the health care safety net for a population of over 3 million people, counting San Diego. And you learn a little bit by doing. And frankly, this issue is always being brought up as somehow being the victim as opposed to the perpetrator being the physician. And when you get into the at-risk populations, this issue impacts the capability of those of us that are providing services more than probably any other single item I can point up to. And perinatal service was a classic example, where you had volunteers not being paid 1 cent, having to pay $90,000 in the 80s for the practice, to protect his practice, when we could provide the perinatal service at $300 a child. Now you do the math. $300 into $90,000 is how many children aren't being born healthy because you've got a tort issue hanging over the physicians who are volunteering. And is the right to litigate more important than the right to be born healthy? So don't think that those of you that say you really care about the poor and the needy, that this doesn't have a major impact. Ask some of us that are got involved. And if you don't think the federal government has a responsibility to get involved in tort in the states, then ask yourself, why is the federal government for decades been providing a special tort program for physicians who work in community clinics? The federal government has already imposed itself on those issues. You and I and everybody in the federal government has already said this is a federal issue when it comes down to providing health services, that the federal government will actually step in with federal programs on this. So to now walk back and say that somehow this is intruding on and we're crossing a line in the states' rights, I think it's a nice tactic politically, but in reality, we recognize that this is something we've got to talk about. And let's talk about the fact that litigation the best way and most cost-effective way of providing quality health care? Is litigation really the way to go rather than looking at a system of mediation and addressing it that way? Is the courtroom where quality control is best done? And as somebody who's actually had the responsibility doing it, I'm telling you no. Just absolutely no. So we've got to be brave about this. And remember, California has had its MICRA, and you know there's huge forces to overturn it. The fact is, California is not exactly run by a bunch of right-wing, pro-business people. Look at the history. But even they recognize that the part that we do have is essential to maintain any kind of health care structure for the over 30 million people that call California home. But these issues have to be addressed, and we got to tell our friends there's got to be a better way over.
Gentleman yield.
Gentleman, yield to me first.
I'll yield to the gentleman from Georgia.
I thank the gentleman, and I'll try to just take about 30 seconds. But another case in point in regard to the federal taking over certain aspects is the National Vaccine Injury Compensation Fund. If it were not for that fund, childhood vaccines would be a thing of the past. And I think most of us on both sides of the aisle would agree that childhood vaccinations against measles, mumps, rubella, smallpox, all of these things are hugely important. But the fact that the vaccine manufacturers were subject to unlimited liability in those instances where rarely there would be a complication from a vaccine, they would no longer be in business.
I'd like to reclaim my
I thank the gentleman for
reclaim my time. And the gentleman from California was pointing out about what determines when a lawyer passes and wants to take on a job. There was a big reason why the gentlelady from California and I introduced bills back in the 90s to hold harmless the materials manufacturers for implants, because the lawsuit wasn't going to the people who made a faulty product, but who had the deep pockets. That's a whole different issue of what drives this machine. But the problem is the tort issue the federal government follows its money. The money of the federal government is going into states to provide health care, not to provide compensation to trial lawyers. And the fact is, if you think that there is not a draw on that, then again, go back and take a look at those of us that are provided the baseline to the highest poverty levels. That's where the risk has traditionally been the biggest problem. And that is where the most of the money is being drawn off more than in the wealthier communities. And it's something that's just not frankly talked about. So I ask that we take a look at this, but as long as the federal government and the federal taxpayer is being required to pay into a system, we darn well have a right to determine that money goes to health care and not to trial lawyers. And I yield back.
Other members, the gentleman from New York, Mr. Engel.
Thank you. Thank you very much, Mr. Chairman. I want to say that I support Ms. Baldwin's amendment. I must confess that I'm conflicted, because I do think that a person who has been maimed is entitled to sue for pain and suffering and not have an artificial cap. But I also think that the medical malpractice fees that doctors are being charged are astronomical and are driving many physicians out of their practice. So I do think there has to be a balance, and I think both sides, frankly, have to give a little bit. But I don't support a cap of $250,000 with one size fitting all. I come from New York, which is a high cost of living state. And I must say that $250,000 is not as great in New York as it might be in a rural state somewhere, rural southern state, let's say. And that's why I think this one-size-fits-all is a very, very bad idea. I do think that we have to look at the whole medical malpractice issue, and I just don't understand why we cannot find another way other than an artificial cap to do this. I think that, I take the tax fight that we're having, and we have the AMT. And the AMT, Alternative Minimum Tax, was put in 1969, I believe, because very wealthy people were using tax loopholes and not paying any taxes at all. Well, it was never indexed for inflation. So now you have a situation in my home state of New York where, average people making $70,000 and $75,000 and $80,000 are caught in the AMT. Now, I can tell you, to live in New York, $80,000 is not a heck of a lot of money. It really isn't for a family of 4 or 5, given what prices are in New York. So here we want to do the same thing. We want to cap it. There's no index for inflation. It just doesn't work. You know, I want to comment on what my good friend Joe Barton said before when he said that we are newfound supporters of states' rights. Well, if that's true, we could say the opposite thing to my friends on the Republican side. You know, they have talked a good game about states' rights through the years, but then when it's something that they like, they want to preempt the states totally from doing what's best for them. I think in my home state of New York, we would want to take into account that $250,000 is insufficient in terms of capping things for pain and suffering. Maybe, again, a rural state might think that's fine.
Would my friend from New York yield?
Yeah, I will in a second, since you called me your friend and you returned the compliment.
Well, you are my friend.
No, I am, and you're my friend. I just don't think that this is a good policy for a state like mine. And the fact, I know Ms. Baldwin said this, but I want to repeat, the language from this amendment is 100% identical to language included in H.R. 816, which is a bill sponsored by another friend of mine, Mr. Gingrey and Mr. Burgess and Murphy, on medical malpractice relating to the health care law. So if it's good enough for the health care law, it's good enough for this. And I yield to Mr. Barton.
I just want to compliment my friend from New York for picking up on what I said and reversing it. I knew that somebody would do it, but I really thought it would be Anthony Weiner. I didn't think it would be Mr. Engel. So I'll give you the first bonus point to a member of the New York delegation for hoisting me on my own petard.
Well, thank you. It probably would have been Mr. Weiner, but the chairman decided to call on me first. So that's what happened. All right, I think I've made my point. I think Mr. Waxman's point about lawyers not taking cases worries me, because I do believe that if someone is seriously maimed or injured, you know, they have a right to be made whole. And if lawyers won't take cases, and that's a problem, that's something that bothers me. But I want to just say to my colleagues, this is an issue that won't go away. And we have to address it. We have to get together, meet somewhere in the middle, and address this issue, because it's an important issue. And I yield back.
Chairman yields back. Other members on the Republican side wishing to speak? Dr. Guthrie, recognized for 5 minutes.
Me?
And Cassidy, Dr. Cassidy.
Yeah. I think we decided in 1965 that the federal government had a role in health care. That's when we passed Medicaid and Medicare, Medicaid being clearly a state program that's co-ministered with the federal government. So that actually, there's no tension here. It's just a question of whether or not we're going to address the impact of torts actions upon health care costs. Because I think we would also agree that there is a impact of lawsuits upon health care costs, and therefore the federal taxpayer. For example, it's estimated that about 1% of the health care costs are associated with the awards given in lawsuits, but about 5% may be related to defensive medicine. Clearly that impacts access. I work in a hospital for the uninsured. Estimates show that every time you increase the cost of a premium by 1%, a significant number of small businesses will drop their insurance. Now, on the other hand, I hear what y'all are saying, and I can accept some of your concerns, but I think we can allay those concerns. Mr. Waxman wonders if this only preempts state law in one direction and not the other, but as I look on page 25, line 10, it begins a passage where it says that if any state law specifies a particular monetary amount that may be awarded, regardless of whether or not this amount is greater or lesser than what is in this act, shall not be preempted. So line 8 and 9, no provision of this act shall be construed to preempt, and it goes on to say any law in a state that either has a higher or lower monetary award. I'm specifically told by counsel that includes punitive caps. If a state has a cap upon punitive damages, then that punitive cap will hold. I'm told that by counsel. If a state like New York decides that a $250 cap is too low, all New York needs to have is a cap. It can be a cap of $1 billion. But in fact, studies show that caps work. Now, that's okay with me because, again, I'm a physician. I'm kind of data-driven. So Mr. Waxman also raised the concern that there's been no studies that show that caps will lower the direct cost of health care. Here's a study from the American Journal of Emergency Medicine from 2010, which compares the rate of head x-rays after a trauma in states with caps and without caps. It shows that as much as a 60% lower rate of ordering CT scans or other imaging studies after head trauma in states with caps. This is a study which shows that there is a direct positive impact upon decreasing the cost of health care if we enact a cap. Next, Dr. Gingrey has also mentioned that there is federal precedent for this because the Vaccine Injury Act has statutory deadlines and a $250 cap on pain and suffering, recognizing that the federal government has a vested interest in controlling the cost of vaccines and therefore access to that. Mr. Waxman also raised the concern regarding rape. Rape is not medical care. Rape is assault. This specifically speaks of health care, not of criminal assault. If a physician rapes, a physician should be thrown in jail, prosecuted to the fullest extent of the law. This offers no such protection, and it specifically says so. Mr. Waxman also raised the concern that there would be decreased access to tort action under a law such as this. But here's an analysis of MICRA in California, and I can submit this for the record, but it shows that there's been minimal or no decrease in per capita incidence of lawsuit filings, malpractice lawsuit filings, from 1968 to 2003, taken as an inflection point in 1985 when their MICRA law was declared constitutional. There is no evidence that there is a decreased number of court filings associated with the passage of this law.
Will the gentleman yield?
Just a second. I'm not sure I'm through yet, man. I'm a relatively new member here, and so I always like to think the truth will prevail, and I'm hoping that as we address some of those concerns, which are valid concerns, that people will look at this and say, wow, no, that's not true. Again, a state can have, and going to the substance of the amendment, Wisconsin can have their fund. All that we're asking is that they also establish a cap, whatever that cap may be, because again, it is a federal interest to control health care costs and to therefore increase access to care, and studies show that caps actually decrease cost, which other studies would suggest would increase access to care. I have 28 seconds, I'll yield.
I thank the gentleman for yielding, and he brought up a very important point. It's not just about cost, and of course $62 billion, very conservative CBO estimate over 10 years is not pennies, but it's also about physician workforce. And he showed the study from the College of Emergency Room Physicians. That emergency room physician at Tucson Medical Center, Dr. Ree, probably would not be there if we don't do something about this situation, because these doctors are not going to go in high-risk specialties and put themselves in danger of medical malpractice every single day. Thank God he was there and saved our colleague's life.
And can I reclaim my time just to say I'll submit these supporting documents for the record?
Without objection. Gentleman from New York, Mr. Weiner.
Thank you, Mr. Chairman. Let me just stipulate something that I think is obvious about these states' rights issues. We all kind of come down on different places depending upon what issue it is. Mr. Barton pointed that out earlier. There's a states' right caucus that one of the original 10th Amendment states' rights people was the gentlewoman, Ms. Blackburn. I think some of you might be on it. We move back and forth. You know, Congresswoman Baldwin and I spent 12 years on the Judiciary Committee. We can probably do this argument from memory. But let's remember something, that a lot of the arguments being made here today in support of the tort cap would be very interesting to hear made in support of the individual mandate, for example. You can say that, too, has an impact on reducing cost, and the ability of one person to opt out increases the cost to everyone else. Mr. Whitfield said that that's why the Medicare program is a national program. These are the exact arguments for why Romney Care was something that he said only can be done state by state, and he's going to give this speech tomorrow. That, in fact, there are a lot of these issues that you need to nationalize. But it does come down to the question of, if you are going to nationalize the tort laws and say that even those decisions, what happened in an individual case, what did a doctor do, a clinic do, what did the patient do, if you don't trust a jury of your peers and of your constituents with that, what's left? Like, what is really, is there anything more foundational than hearing the evidence in a case and making the decision? Now, I know my colleagues believe that we here in Washington can make those cases. You theoretically could if you want to, I'm sure. I mean, you'd get some pushback, I'm sure, but you can federalize the entire thing and say every single tort case should go to a federal court. Maybe you should just do that and just cut out the middleman. The fact is that this does save some money. Hardly any, but it saves some money. It saves roughly $6 billion, between $5 and $6 billion a year. The entire expenditures in healthcare for the, as my colleagues know, who frequently point out their doctors, $2.7 trillion a year. I mean, I'm not a math guy, but you know, we saved $1.2 trillion with Obamacare, with the Affordable Health Care Act. You know, so yes, you can probably do some things to reduce some costs, but the question is, what responsibility ultimately do you give to citizens to sit on a jury, to hear their cases? If not this, why anything? Like, for example, why shouldn't the next thing we take over is all criminal law? Maybe every single, because crime, right, you know, if you don't have the death penalty in every state, maybe someone's going to go to the next state and commit a crime. So maybe we should have the national death penalty for all crimes of a certain sort. Maybe we think that in some states the sentence for rape is too low, or for sexual abuse is too low, or for assault is too low. Why don't we nationalize those things? Because then people may go over state lines to commit those crimes. The question becomes, what do we leave to our citizens? And tort law, a harm one person did to another, as heard by a jury, is the very most foundational thing. And let me just say this. You know, I agree with Congressman Engel. I agree with many of my colleagues. I'm very concerned with what insurance companies are charging. But I'm concerned about that. Put that in the law, you know, and we might be able to do business. If you say, if you do an exchange for these things, insurance companies are capped or they can't raise above a certain level. The fact is that, you know, look, it's so transparent sometimes that all my friends on the other side of the aisle want to do is make sure insurance companies benefit. And who is it coming out of in this case? The rights of your citizens in your states, in your districts, to make the most foundational things. You know, we trusted them to elect you. We trusted them to make that decision. Why can't we trust them to sit on a jury and say, you know what? This case is more serious than that case, or this case, I believe, here's what the appropriate remedy should be. In this case, I trust this judge that I also elected or was also appointed in my state. Why do we have such contempt for that?
Will the gentleman yield?
Certainly.
First, of course, this does not preclude a jury trial. Secondly, Mr. Waxman, I'm told, is the one that authored the Vaccine Injury Act, and so it may be that he could give us insights why.
I understand. Let me just come back. I'm not saying that you're substituting for a jury. You're substituting for their judgment. That's what you're doing. You're saying that I want to have a jury, but do not cross me, your congressman, who has decided this is the cap that I want.
But again, Mr. Waxman,
as far as here, let me just. I'll address the second part, but I already did once. I will stipulate to the idea there are different questions on where the line should be drawn on different things. I agree with that. But is there anything? I mean, torts, which is like two citizens or two entities trying to decide who did what. Honestly, do you really believe you know what the appropriate level should be, what the appropriate cap should be in every case, that you want to write it here? That doesn't seem to me in any way to be a conservative way to look at your role as a congressman.
There are other members wishing to speak on the Republican side? The Democrat, Mr. Butterfield, recognized for 5 minutes.
Thank you very much, Mr. Chairman. Many of my colleagues may know that I spent 30 years in a courtroom, 15 of those as a lawyer and the other 15 as a judge. Of those 15 years, 13 years as a trial judge and 2 years on our state Supreme Court. And so I've seen medical liability cases time and time again, and so I have some expertise in this area. I had come today prepared to speak off the cuff in opposition to this amendment, but I was given a letter this morning that I think ought to be read into the record. The letter was written by a gentleman named Chief Justice I. Beverly Lake, Jr., who was the former Chief Justice of our state Supreme Court. I served with Justice Lake. He's a very distinguished Republican in my state. If he were here in Congress, he would be very comfortable on the other side of the aisle. The letter reads as follows. In my opinion, the proposed cap on non-economic damages is unconstitutional. I served on the North Carolina Supreme Court for 12 years and was Chief Justice from 2000 to 2006. I previously served as a Superior Court judge for 6 years, was a state senator for 2 terms, and was Deputy Attorney General for 7 years. Throughout my legal career, which has spanned over 50 years, I have sought to uphold the North Carolina Constitution, the foundation of our laws. For over 200 years, the North Carolina Constitution has provided that in all controversies at law respecting property, the ancient mode, which is what the gentleman from New York was talking about, the ancient mode of trial by jury is one of the best securities of the rights of the people and shall remain sacred and inviolable. The court has long recognized that compensatory damages, including damages for mental and physical pain, is a form of property protected by the constitutional right to trial by jury. He went on to say that when I served as Chief Justice, a unanimous court, and I happened to be on that court, a unanimous court expressly reaffirmed the principle in Ryan versus Kmart. We stated that compensatory damages represent a type of property interest vesting in plaintiffs, while punitive damages are not a vested property interest. North Carolina citizens have a sacred and inviolable right to have a jury determine the amount of compensatory damages, including non-economic damages, under our Constitution. The right to have a jury make that decision cannot be eliminated or restricted. And then Chief Justice Lake went on to conclude by addressing a case that came out of the Georgia Supreme Court. My friend Dr. Gingrey and Mr. Barra will probably recognize this case. The Georgia Supreme Court recently reached the same conclusion, striking down a similar law in Atlanta oculoplasty surgery versus Nesselhut. In 2005, the Georgia legislature enacted a $350,000 cap on non-economic damages in medical malpractice cases. Georgia's state constitution protects the right to a jury trial, as does ours, stating the right to trial by jury shall remain inviolate. Because the determination of damages has always been the jury's province, and non-economic damages have always been a component of compensatory damages, the damages cap unconstitutionally, this is the Georgia Supreme Court, the damages cap unconstitutionally infringed on the right to a jury trial. The court concluded the very existence of the caps in any amount, is violative of the right to trial by jury. I ask unanimous consent to include a copy of this letter.
Will the gentleman yield?
Yes.
I thank my colleague from North Carolina yielding, and at the onset of his remarks, I commend the gentleman because he brought up a point that, you know, this is really not, or certainly should not be, a partisan issue. There are members on both sides of the aisle that were healthcare professionals in their previous life, and there are those who were attorneys, indeed even trial attorneys, as the gentleman said is part of his resume. And certainly the Republican Supreme Court justice that just happened to get that letter to him this morning. You know, again, he spent his whole life in the legal profession. So you come at this from
reclaiming my time. The point that the Chief Justice is making, and I'm trying to make today, is that these damages are a property right. And your court in Georgia and my court in North Carolina has expressly stated that. And you cannot take away a property right once it is vested. That's the point that we're trying to make. I yield back.
Chairman yields back. Gentleman from Pennsylvania, Dr. Murphy.
Thank you, Mr. Chairman. Just a couple points here. I know when I was a state senator in Pennsylvania, we dealt with several issues regarding medical liability reform. We dealt with contributory and comparative negligence, joint and several liability, contribution, vicarious liability, expert testimony, periodic payments, collateral sources, prejudgment interest or delay damages. And one would hope that would have dealt with a number of things. We did not have caps on punitive damages because according to the way the Pennsylvania Constitution is written, back in the early 1900s, there are no caps that can be imposed on anything, so it would require a constitutional change. This bill would make some differences in that. However, despite that, there are still some concerns in Pennsylvania as there are with other states. For example, in Philadelphia, you have many sites that deliver babies have closed, except at academic hospitals. You have medical malpractice costs now that can be close to $200,000 a year, which has resulted in multiple hospitals throughout the states, entire classes of OBGYNs who graduates leave the state and go to other states. In particular, a high number seem to want to go to states like Texas. Now, I do want to point out that we had our hearing on this bill a couple weeks ago. I specifically asked one of the persons presenting at that time, I believe his name was Wolfman, about this issue. And I said, were there differences in states that have caps and states that don't? And he said, yes, indeed. The states that don't have caps, there is a difference, a clear difference in improved quality in medical care. I believe what he was pointing to is that when you have unlimited damages, health care is better. And despite my asking a number of times during that for him to submit that information to the committee, it has not happened, nor has it come to my office. My only assumption is that it doesn't exist. I make reference then to Dr. Cassidy's note 2 here on some of the issues with regard to differences that have occurred in states with or without punitive damages. Look, we all want to see better health care. If this was an issue that allowing unlimited damages would yield better health care, then, my gosh, that's the health care we should have performed. We should have said if the way to get doctors to do better care is to sue them for 70 or 80 or 100 or $200 million every time they do something wrong, then by the time we're done with this, we'll have cured everything. That's not the case. And the case is that this is a huge interstate problem because states that have variability in these laws, doctors do leave because they can no longer afford to practice in one state or another. It's tough enough then within a state where doctors flee, you have counties that may not have OBGYNs or neurologists or neuroradiologists or neurosurgeons or specialists in neonatal care. That being the case, when there is a high-risk delivery or pregnancy, where does that mom go when minutes mean life? And if someone is having a stroke, where does that patient go when even to get a helicopter there and to another high-level hospital where these physicians are practicing, hours mean, or minutes mean brain death? This is a huge healthcare issue in America, across the nation, and it is important that Congress sees this as an issue we have to deal with across this nation, America, because delayed care, denied care is lives. And it's the quality of life for so many babies and so many adults with medical problems that continue on or worsen because they cannot get access to care with this. It is not just an argument about states' rights here. Let's get back to the root of the issue. It is about patients, it is about health care, and if someone can show me that allowing anybody to sue a doctor for any amount of money brings better health care, then let's do it. That is not the case, however. We have to figure out ways to improve quality of care, but that begins with allowing access to doctors, which you don't have when they flee a state. And I yield back.
Gentleman from Washington State is recognized for 5 minutes.
I'll show you one case that improved health care. It was about a little 4-year-old girl who, because of a defective catheter, ended up with very, very severe burns, chemical burns to her bladder. And as a result of the jury verdict by 12 citizens, not politicians, the medical care delivery system changed the way, or manufacturing system, how they manufacture catheters so their 4-year-old girls didn't get burned bladders. And I can point to that case, and I'll give you the name after we're done with this hearing. But I want to make 2 points. Both patients and physicians have legitimate concerns here, and I want to address both of them. First, the patients, and I want to tell you about one patient. I'm just going to call her Mrs. Smith. She went in, she had a lump in her breast. Doctor prescribed a biopsy. They did the biopsy. Come back, they told her she had a malignancy. She had a double radical mastectomy. She then developed an obstruction as a result of that surgery of her bowel and ended up having about 2/3 to 3/4 of her bowels removed. She then developed a blood clot as a result of that surgery, developed gangrene in her leg, and they had to remove her leg, I believe, above the knee. And after her double radical mastectomy and the removal of most of her bowel and one of her legs, a doctor had to walk into her room and explain to her that there'd been a mistake in the pathology report. She actually had a benign situation and she didn't require any of those surgeries. Somebody made a mistake. And I don't know what the proper justice is in that situation, but I know that it's not up to 535 people who've never met that woman to make that decision. It's up to her neighbors, and the jurors ought to be able to do that. And you folks distrust jurors so much. In your bill, you put it specifically that you would keep this limitation on their right to make a decision secret. In your bill, it says you won't even tell the juries about the limitation. You'll let them issue an award of maybe $500,000, and you don't even tell them about that limit, and then you cut it down after they leave the courthouse. I don't understand why you don't trust the people who elect you to make these decisions. That's the patient. Now let me address the physician. Physicians have real legitimate concerns about liability that all of us understand. And there are some things we can do to reduce that concern. But let me suggest this is not the way to go about this. What I believe we owe physicians is more predictability and certainty about their standards of care. We need to have standards of care that they can point to saying, I followed the standard of care. And those standards of care need to be based on medical evidence. And in our health care bill that we passed, we have a variety of tools to help the industry develop more evidence-based standards of care. So when a kid comes into an ER room and they've had a bump on the head, and there's a question whether or not they get a CT scan, those doctors have a standard of care to point to based on evidence that they can say, I followed the standard of care, and I'm not liable if something goes wrong in an unpredictable way. Our healthcare reform bill, in many, many ways, are going to help the medical community move to those accountable care organizations with legitimate standard of care. And I think it's going to help the profession a lot. That's the way to go about this, not as an assault on democracy, which this bill is, in its most fundamental form. And I'll tell you why. You know what happens? Go see, if you, before you vote on this bill, go watch the movie 12 Angry Men and watch a jury in action. They don't have lobbyists in the jury room. They don't have 30-second attack ads. They have the most pure form of democracy known to man, which are 12 randomly selected citizens, and we ought to respect that and not attack it like this bill does. I'll yield to anybody who wants to have some time.
Will the gentleman yield?
To anybody, you guys fight it out, whoever wants to.
Can I just ask one question? Yes, I would like that study, but with that, there is no doubt. I mean, we're not arguing the quality and the importance of juries in our system. That's critically important. It's helped make our nation great. But it's also a matter that, yes, there are individual cases where people have altered things. What we're looking at overall is this question I'm still looking for. Can someone show me a study that's showing having unlimited damages in a state makes that state's health care better than in a state that doesn't have, that does have limits on damage? That's what I'm looking for. If you have available to that study, appreciate it. I'll yield.
And it's important to note in the study I quoted from the American Journal of Radiology, there are currently standards as to which head injury patients should be imaged. It is the states with caps that had a greater adherence to those standards. Standards by themselves do not, if you will, give immunity or even comfort.
Well, let me just point out the standards I'm talking about. We need the medical industry to develop standards of practice. And if we do that, well, they aren't there. Here's the problem. ER room doctors today do not have standards they can rely upon. That's what we need to develop, and I'm out of my time. Thanks a lot.
Chair would recognize the gentleman from Illinois, Mr. Shimkus.
Thank you, Mr. Chairman. As much as I'd like to move to the vote, this is a good debate. A couple points that have been raised. Remember when the Secretary of HHS was here, you know, she admitted to double counting the $500 billion. So when we talk about the $1.2 trillion saved in the health care law, that doesn't count the $500 billion in the double counting. States can raise the limit on this cap. That's part of this debate. My friend from Washington State does raise the issue of a standard of care, but in the health care law, no protection. If someone operates under a standard of care, there's still no protection. And this will be the same debate that we'll have when we go to there's going to be an amendment on medical devices and drugs. There we do have something that's been approved at the federal level, and the tort system can still go after them, even though our national government said these are safe for this process and procedure. The citizen, going on with Dr. Murphy, the citizen does have a right. We're talking about the right of citizens. The citizen has a right to have a neurosurgeon when they have a major head trauma in this country, but they're not in locations, especially in rural areas. Why? Because this process, and let's conclude this with talking about the federal court and federalism. The CRS report in 2003 said, enactment of tort reform legislation generally would appear to be within Congress's power to regulate commerce and would not appear to violate principles of due process or federalism. They also say, in concluding that Congress has the authority to enact tort reform generally, we refer to reforms that have been widely implemented at the state level, such as caps on damages, limitations on joint and several liability, on the collateral source rule. James Madison's also quoted as saying when he debated the Commerce Clause, at the Virginia Convention, when he called to ratify the Constitution, says, all agree that the general government ought to have the power for the regulation of commerce. There are regulations in different states which are unfavorable to the inhabitants of other states. This will not be the case when uniform regulations will be made by Congress. And that is the case that, why is this important? Illinois has passed 2 pieces of tort reform legislation. They did help provide more access. They did help lower premiums. They were both struck by the state Supreme Court. That's why now, for my citizens to have the same access as any other citizen in this country, we need to have medical liability reform. This is what this bill does, and that's why I support it.
The gentleman yield.
Will the gentleman yield?
Gentleman yield.
Who is? I'll go to Dr. Gingrey, then I'll go to you, Anthony.
And I thank the gentleman for yielding, and I thank the gentleman from Washington State for bringing up the Smith case, as he described. There would probably be a minimum of 10 defendants in that case, and if it were tried in the state of Georgia, and I'm sure if it was tried in the state of Washington, you would expect that the plaintiff in this particular case would probably end up with about $100 million worth of economic award, and justly so. And $250,000 worth of non-economic if H.R. 5 becomes law. And I thank the gentleman for
And I'd like to yield to gentleman from New York.
I appreciate the gentleman from Illinois. I guess what it does kind of beg the question. I don't disagree with the gentleman that there is a legitimate federal interest. This is the whole individual mandate argument going right now. You made a pretty good argument for why the individual mandate is constitutional. But I guess the question is where do you draw the line as an individual member of Congress? If residents of Illinois don't have the ability to hear a trial and make their own determination what the cap or the floor should be, why would you give them any rights to hear any cases? What cases would you allow them unfettered control of? Are there any cases?
Well, I would just say that states are allowed to set a cap at a level above this. So if that's the debate, my issue would be, in its real world, is that if from the state capital to Metropolis, right next to Paducah, Kentucky, probably 35 counties, if there's no one neurosurgeon there because the specialist cannot afford medical liability and something happens, a major head trauma in South Central Illinois, it is a life and death aspect of getting to that care. What I'm trying to say in the federalism debate is that our citizens have the same right to access that service as any other citizen, and I think that's what Madison was alluding to when he argued the Commerce Clause before the Virginia Assembly, and I yield back my time.
Gentleman's time has expired. The gentlelady from Illinois.
What confuses me about this whole debate is that I think we can all agree that the problem that faces physicians is that they are charged so much money for their liability insurance that some of them find it difficult to practice. But why then we're looking at the victims of malpractice and not at the insurance companies really is perplexing to me. Let me give you an example. When I was early in my career here, I'm here 12 years, so it must have been in my second or third term, there was a hearing in Philadelphia, and the insurance industry was testifying. And I said to them, well, if we were to set this $250,000 cap, give me an estimate. Would you be able to reduce your rates by 25%? Oh, no, we couldn't make that commitment. Well, how about 20%? No. We got down to 5%, and the insurance industry representative would not make any kind of commitment that as a result of limiting damages by putting a cap on liability, that they would actually reduce rates. Well, I think that this committee could get together and look at what about the practices of the insurance industry that are making it impossible for doctors to practice, good doctors. I mean, why can't we work out a way that we figure out how to weed out the few bad doctors that are really causing the problem? Why can't we talk about some sort of experience rating rather than giving all specialties the same kind of rates, meaning good doctors and bad doctors? There are all kinds of ways at doing insurance reform rather than taking it out on the patients and making a discrimination between someone who's worth a lot of money and a child who is not. And later I'm going to introduce an amendment dealing with nursing home residents who aren't really worth a nickel because they aren't, don't have, they aren't worth anything to anybody.
Will the gentlelady yield?
And so, well, yes, I will. I yield.
Thank you. There's an article from the GAO. One, I have great sympathy with what you're saying. And in the theoretical, I have great sympathy. In fact, my gut says, oh, yeah, right. On the other hand, there's a GAO report from 2003, a little dated.
I say go with your gut, but go ahead.
I'm a gastroenterologist, so that works.
See? For sure.
There is a GAO report from 2003 which specifies that there's multiple factors related to increased premium cost. And they specifically talk about what would be the impact of caps upon future cost. And they say since some of the insurance companies' current income is there to pay future cost, and because some of their income is related to investment properties, that it's like I assume landing a plane on a aircraft carrier. It's a moving deck, so it's difficult to establish a one-to-one relationship between a decrease in premium and any sort of cap. The other thing I'd like to point out, in that analysis done of MICRA in California, there's been a
well, reclaiming my time for a minute. What you're saying is that insurance companies are partly setting their rates on the success of their investments. Well, then we shouldn't be talking about using insurance premiums as a way to talk about medical malpractice.
But if I may, that's only one component. Another component is future claims. And again, the same GAO report says that if you capped, at least theoretically, if you capped pain and suffering, that would allow greater predictability, and instead of having wild fluctuations in premium cost, would allow some stability thereof. And again, I'm just quoting GAO.
Okay, well, reclaiming my time, the fact of the matter is that liability claims have been rather stable. They are pretty predictable. They have not wildly fluctuated. That's one thing that has been a pretty steady thing. So I would say that let's work together on insurance reform, and I think that we can make some serious headway with this problem. And I yield back.
Gentlelady yields back. I'm hoping that we can be prepared for the vote, and I've talked to Mr. Waxman, and if we can vote now, we'll bring up the Barrow Amendment next. We're going to limit debate to 10 minutes on either side. We'll vote on that amendment. We'll adjourn until precisely 1 o'clock, if that meets everyone's approval. So if there are no other members wishing to speak on the amendment from the gentlelady from Wisconsin, the clerk will call the roll.
Mr. Barton. Mr. Stearns. Mr. Whitfield. Mr. Whitfield, nay. Mr. Shimkus. Mr. Shimkus, nay. Mr. Pitts. Mr. Pitts, nay. Mrs. Bono-Mack. Mrs. Bono-Mack, nay. Mr. Walden. Mr. Walden, nay. Mr. Terry. Mr. Terry, aye. Mr. Rogers. Mr. Rogers, no. Mrs. Myrick. Mrs. Myrick, no. Mr. Sullivan. Mr. Murphy. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mrs. Blackburn, nay. Mr. Bilbray. Mr. Bilbray, nay. Mr. Bass. Mr. Gingrey. Mr. Gingrey, no. Mr. Scalise. Mr. Wada. Mr. Wada, nay. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper, nay. Mr. Lance. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Guthrie, nay. Mr. Olson? Mr. Olson, nay. Mr. McKinley? Mr. McKinley, nay. Mr. Gardner? Mr. Gardner, nay. Mr. Pompeo? Mr. Pompeo, nay. Mr. Kinzinger? Mr. Kinzinger, nay. Mr. Griffith? Mr. Griffith, aye. Mr. Waxman? Mr. Waxman, aye. Mr. Dingle? Mr. Markey? Mr. Markey, aye. Mr. Towns? Mr. Towns, aye. Mr. Pallone? Mr. Pallone, aye. Mr. Rush? Ms. Eshoo? Ms. Eshoo, aye. Mr. Engel? Mr. Engel, aye. Mr. Green? Mr. Green, aye. Ms. DeGette? Ms. DeGette, aye. Mrs. Capps? Mr. Doyle? Mr. Doyle, aye. Ms. Schakowsky? Ms. Schakowsky, aye. Mr. Gonzalez? Mr. Inslee? Mr. Inslee, aye. Ms. Baldwin? Ms. Baldwin, aye. Mr. Ross? Mr. Ross, aye. Mr. Weiner? Mr. Weiner, aye. Mr. Matheson? Mr. Matheson, nay. Mr. Butterfield? Mr. Butterfield, aye. Mr. Barrow? Mr. Barrow, aye. Ms. Matsui? Ms. Matsui, aye. Ms. Christensen? Ms. Christensen, aye.
Other members wishing to vote, Mr. Lance? Wait,
Mr. Lance, nay.
I don't believe you called my name.
I didn't.
Mr. Upton votes no.
Mr. Upton, nay.
Mr. Bass?
Mr. Bass, nay.
Mr. Barton?
Mr. Barton, nay.
Kathy McMorris Rogers?
Mrs. McMorris Rogers, nay.
Dr. Murphy?
Dr. Murphy, nay.
Mr. Scalise?
Mr. Scalise, nay.
Mr. Stearns?
Mr. Stearns, nay.
Are there other members wishing to cast their vote? If not, the clerk will tally the roll.
It was close, but the late precincts swung it to the numbers. Early voting favored the Ds, but the late precincts came in heavily off.
I got 30.
Mr. Chairman?
Yes.
The tally is 20 aye, 29 nay.
29. 29 nay, 20 aye. The amendment is not agreed to. Now, are there further amendments to the bill? The Chair will recognize Mr. Barrow.
I thank the Chair. I have an amendment at the desk.
Clerk will read the title of the amendment.
An amendment by Mr. Barrow of Georgia.
And without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes in support of his amendment.
I thank the Chair. My amendment doesn't really go to the wisdom of caps as a way of dealing with the problems of medical liability in this country. It really goes to the power of us to regulate in this area and calls for restraint in the exercise of that power where it really doesn't exist. As for the wisdom of caps, it may seem strange to some folks that the way to address this problem is to limit the rights of the truly deserving. I understand the frustration folks have with frivolous lawsuits, but so far as I've been able to tell, all experience has shown you've never been able to restrain the truly undeserving by limiting the rights of the truly deserving. You haven't been able to get at the truly greedy by limiting the rights of the truly needy. And that goes to the wisdom of the measure. I'm not addressing that. I want to address the power of us to regulate in this area and call for restraint in the exercise of that power where it doesn't exist. Now, I begin with this little document right here, the Constitution. I find that the folks who adopted it adopted some amendments right at the outset. One of them, Amendment 7, says something about where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. Funny thing, they didn't say whether the right amount in controversy exceeds $20 but doesn't exceed $250,000. I take my Constitution neat, just the way it's written. But let's drop down to Amendment number 10, which I think is the meat and potatoes of this issue. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Now, I have listened with great interest to the discussion about the federal government's interest in this, and I have no doubt whatsoever that the activities of practitioners of the healing arts, corporations, citizens, the commercial practices of purveyors of the healing arts can bring themselves within the scope of Congress's power to regulate commerce between the states. I have no doubt that the antitrust laws can reach this area. I have no doubt that the federal government can condition the exercise or the conferring of benefits in the form of health care upon conditions for the enjoyment of it. I have no doubt the federal government can attach strings to what it spends money on. But this amendment addresses the fact that the bill before us goes much further than that. It purports to address directly and to regulate the relations between doctors regulated by states and their patients within the same states. Now, this is a power where there is no, and in cases where there is no federal connection and no federal dollar whatsoever. This is a square exercise of the police power that has been within the realm of the states since the beginning of the Republic. A lot of the discussion so far has been on the question of, well, you know, we've always done it this way. We've never gone into this area before. There's a reason why we haven't gone into this area before, because this is an area that's squarely reserved to the states. Now, under the states, under our Constitution, the states are the highest authority as to what their law provides. Congress has no jurisdiction whatsoever to legislate in an area that is reserved to the states. And in the relations between doctors and patients where there's no federal connection whatsoever, this is a matter that's squarely reserved to the states. So if you wanted to pass a law that said only cases involving the provision of care that the federal government pays for, that might be one thing. But we're going way beyond that with this bill. Now, my amendment does not gut the bill. My amendment simply says that where the highest lawmaking authority in the state, where the Constitution of the state has prohibited caps, or where the courts, construing the constitutions of their state, have said our law, the supreme law of our state, prohibits caps and addresses the issue of the interests of healthcare providers versus the rights of their victims in this way, then this bill will not affect that. So what it does is my amendment makes room for this bill to legislate in the area where the states have moved into this area by statute. It allows them to legislate in the area, allows us to legislate in the area where they've regulated this area by ordinance. But where the supreme power of the states, as expressed in the Constitution of those states, has said you cannot go into this area, we respect that. Now, Mr. Shimkus put his finger on a pretty good test of the police power when he cited one of the founders, Madison, in saying states pass laws that are unfavorable to the inhabitants of other states. That's a pretty good test of the commerce power. It's also a good test of the police power, because when you're doing things that you think are unfavorable to the inhabitants of your state and your state only, that have no unfavorable impact on folks in other states, is a pretty good measure of the police power that is reserved to the states. And if anything, if you think that the balance being struck in various states is improper and unfavorably benefits victims at the expense of providers, if that's what you think, then by definition, the nature of that problem is one that unfavorably burdens folks in that state and in that state only. It has no adverse impact on folks next door. In fact, if anything, it has a benefit on folks next door if it causes the providers to go someplace else. Now, my daddy taught me a long time ago that the fittest test for the exercise of power is restraint in its exercise. That goes double when you're trying to exercise a power you don't have to begin with. And with that, I yield back.
Chairman yields back. Gentleman from California is recognized for 5 minutes.
You know, as a former local elected official, I appreciate that argument very well, and I wish more people had talked about this over the last few decades. But the gentleman's got to recognize that this is not just an issue in isolation. Where the federal dollar goes, not only goes the rights of the federal government to condition and impose, but also goes the responsibility. And one effect that, I'll just say this as a Californian, is that, yes, Nevada has physicians bailing out going into California over the tort issue. At least that's what, my brothers are telling me in Vegas. But the fact is Californians are being asked through the federal system to pay taxes to subsidize states that do not have those limitations. And thus, as the money goes down, that's the reason why we have a 21 drinking age. We do it again and again about basically imposing on states on the condition based on the condition that we're paying for it or paying for a portion of it. That is why the federal government steps in on a lot of issues on this item, especially, as I pointed out before, the community clinics in your state have special federal programs subsidizing and protecting them. And it's basically tied to the fact that we have federal funds going in. What we have done now is expanded the federal government's shadow and footprint over local communities with imposition of federal mandates on health care. And can you not believe that where the federal mandate for health care and the federal funds for health care goes, that somehow the court in litigation is not going to follow eventually? And especially when you get to punitive. Let me just say this, and maybe we can find, when you talk about punitive damages, this is by definition a punishment. This is supposed to be a deterrent. And it's kind of interesting for myself, who is at the public agency being sued by a lot of wealthy lawyers, I want to point out, that why does punitive damages go to the attorney and the plaintiff? Why, it seems the logic as somebody who provided health care that you're making people whole with other litigation and you're taking care of damages. But when it comes to punitive damages, why is it going into some private property pocket? There's where maybe we can agree that all punitive damages should go to a public fund to provide health care to the public. And just like we do when we do penalties to criminal cases. But that's what's happened, is this become a lottery system. And if you put any limits at all, you have a huge impact, and California has pointed that out, because now you have reduced the lottery factor. We reduced the gambling and the rolling of the dice. And I know there are those who say, oh, attorneys will not participate if they don't have a shot at winning the lottery. Well, frankly, I don't think our courts were ever designed for that, and I don't think our founding fathers ever perceived that jury trial will be used as a lottery system rather than a system of compensation and reimbursement for property rights lost or taken. But I think that the one thing we can talk about here is how do we address this issue and its impact. And let's face it, it's not cost effective to have a lottery system tied into our healthcare system. And as long as the federal government's paying for it, we'll get into it. And I just want to point out, there was a great argument by a colleague on the other side of the aisle about having a standard that if physicians stick to or medical providers stick to, we'll be able to basically be exempt from these kind of damages. Well, it's kind of interesting. We talk about, look at the review that FDA is doing. It's doubled in the last 24 months for medical devices. Is this body now willing to say if FDA approves a medical device, we will not allow tort actions against those medical devices because they have played by the rules and the standards we've set? No, we sort of back away from that. This is a legitimate issue we should talk about, but when it comes to punitive, the fact is punitive damages now have become a lottery. Let's work together to eliminate that lottery factor.
Will the gentleman yield on that final point?
Go ahead.
I guess first I was taken by 2 points you made. One, that the Founding Fathers could not have imagined this scenario, therefore we, the collective wisdom of the Energy and Commerce Committee, are going to substitute ourselves for the Founding Fathers, something I don't usually hear.
Excuse me, yield back. My point was that they could not perceive that the federal government would be imposing on states that they had to spend federal funds for something that was mandated on them. And once the federal dollar goes into a state, the federal government's oversight on that not only is a right, it is a responsibility. If you don't want the federal government to be imposing restrictions on the use of federal funds, then the federal funds should never be required to go into the state or allowed into the state. That works both ways. I yield back.
Gentleman's time has expired. Remember, we wanted 5 minutes remaining on each side. Mr. Waxman is recognized for 5 minutes.
Well, I want to yield to the author of the amendment, but I do want to point out to my colleagues that the amount of federal dollars that goes to pay for medical negligence costs, a very small amount. We spent $2.5 trillion on health care in 2009, and according to the former Brookings Institution fellow Greg Block, the costs associated with medical malpractice accounted for a small and steady fraction of health care costs and could not be blamed for the continuing increase in those costs. We don't even pay for a majority of health care costs. Most health care costs are through the private sector. Most people have their health insurance through their jobs. We pay for health care under Medicare and Medicaid. It'll be more when the Affordable Care Act goes into place because there'll be subsidies for people to buy private insurance with federal dollars. But right now, we don't pay for most of the health care. Suddenly, we're going to tell all the states in the country that they can only have one system of malpractice laws. And I know my friend from Louisiana said it, the states have some flexibility, but I don't read it that way. They have no flexibility on a cap. They have some flexibility with other laws, but it's spelled out where they have flexibility and where they don't, rather than let them decide for themselves. But Mr. Barrow's point is a different one, and I want to yield to him because he is speaking to the constitutional issue itself, both our federal constitution and the state constitution.
I thank the gentleman for yielding. I'd simply point out again that this bill before us goes much further than the federal dollars. It goes where federal dollars do not go. If there were a serious measure before us to try and condition the exercise of benefits paid for by federal dollars upon certain, if you want to attach strings to benefits that are paid for by federal dollars, that's one thing. But this goes much further than that and goes directly to an area that is squarely reserved to the states. Look, the ability to regulate the relations between professionals of one state and their clients of that state is state action. It is not commerce. It has always been regarded as state action because it is state action. And this bill goes where federal dollars do not go. I'd say to folks who don't like the way some states are doing it, there are 10 states whose constitutions have been held to deal with this, 4 where their constitutions expressly prohibit caps. And there are 6 other states, like mine, where the supreme judicial authority in the state has construed the state constitution as prohibiting caps. And there are a dozen other where that's in litigation. If you don't like the way states are handling what our Constitution makes their business, my suggestion is, as you run for the state legislature in those states, if you think you can do their job better, go do their job. But out of respect for federalism and the rights of the state to regulate within areas that are squarely confined to their jurisdiction, they have a right to be wrong. You may think they're wrong, but under our federal system, the genius of our federal system is that time may show that the guys you think are doing it wrong are doing it right. Holmes said time has upset many fighting faiths. And a lot of folks here are willing to have the same old fight over and over again. But if time does upset fighting faith, the only way we can prove that in the laboratories of democracy is over time and allowing the states that have the right to do it their way to try it their way. Because after all, they may be right after all.
Gentlemen, yield back.
Yes, sir.
On one point, someone mentioned the idea of a uniform law on the drinking age. Well, that law has not been decided by Washington. That law was fashioned in the tricky way that Washington usually works. If a state wants to get certain kinds of money, they have to pass a law to have 21 as the drinking age. This bill doesn't even go through that kind of pretense. It says we are now establishing for the United States of America a medical malpractice law, which will involve states to set the standards for medical licensure and still do the courts, still run the trials. But they have to do it under federal restrictions. And I wonder if that's really constitutional myself, although I gather it's been an open subject. But we are now establishing a federal law. We are saying this is the only way you can do it. If there's a medical malpractice claim, it has to fit under a cap. It has to fit under these requirements. If there's intentional negligence, the punitive action can only be at a certain amount. And so even if it's a punitive thing, there's a limit on the damages. I support the gentleman's amendment. I'll yield to anybody the few seconds I have. If not, I yield it back.
Chairman yields back. No other members or Mr. Terry?
Move to strike the last word. I rise in support of the gentleman's amendment. As I have tried to reserve as much power for the states, I've stood in front of crowds for years, well, crowds of maybe 2, 3, 4 people.
That was your family?
Yeah, and that included my family. Thanks, Mike. But
You've got good legs. You've been pretty fast, right?
Yeah, but always said that I was a 10th Amendment person.
I really feel that we need to reserve as much for the states. When I look at Article 1, Section 8 of the Constitution, I don't see a federal power over tort or damage law. That was obviously reserved to the states. If you look at legal history, tort law was inherently a state or local issue. Staying consistent with the same reasons why I passionately opposed the National Health Care Bill was that it wasn't provided within the Constitution, that it should be reserved for states. And when we look at the states, most states have done something. Some have done differently than what's specified in California or Texas, but they did it up to what was necessary for their state to keep doctors there, to keep the high-risk areas, OB, emergency rooms. They dealt with those type of things. I've given a lot of thought, having legal experience and legislative experience, that probably the best way to protect physicians from frivolous lawsuits isn't necessarily a cap, but a medical review panel that's truly unbiased, that's of expertise, so you know if you've deviated from the standard of care, that then that person could proceed forward to the damage aspect. States that want to go there no longer can. They are preempted by this provision, and I would encourage my colleagues on both sides of the aisle here to actually read Section 11, because we have been told that the states still have their rights, but it's very clear in the plain language that this act preempts all of the state laws regarding damages if they are any different than what's in here. And that's it. So frankly, even Nebraska, that has the most prescriptive damage caps in the nation, would be preempted by this act because they don't control attorney's fees, or they don't specifically set out the offsets if there's any other contributions. Read it. This preempts probably every but California's and Texas's medical liability laws. So it is very clear that it violates states' rights to me. It is very clear that it is inconsistent with the 10th Amendment and the Article 1 of the Constitution. Therefore, I'm going to support the gentleman's amendment. And
will the gentleman yield?
Sure.
I thank the gentleman for yielding, and you know, he's an attorney, the author of the amendment. My good friend and colleague from the great state of Georgia is an attorney. We all carry our pocket constitutions with us, and we can quote Article 1, Section 8, Clause 3 in regard to the Commerce Clause, and I would ask my gentleman friend from on this side of the aisle from Nebraska, in regard to states' rights and the 10th Amendment and federalism, would he consider a vote against the federal ban on partial birth abortion a violation of that principle? Clearly, there are examples where the federal government must act, where the state governments have failed to act, or the state Supreme Court may overrule the legislatures in the various states who want to enact legislation. And
the gentleman yielded. I'm sorry, I take back.
Yeah, I yield back.
Frankly, that case that you mentioned is Carhart versus the state of Nebraska. So I know a little bit about that case, and it was state law that banned that. I would love to have the abortion issue back at the state level. Yield back.
Gentleman's time has expired. We're prepared now, I think, to vote on this amendment, and the clerk will call the roll.
Mr. Barton? No. Mr. Barton, nay. Mr. Stearns? Mr. Stearns, nay. Mr. Whitfield? Mr. Whitfield, nay. Mr. Shimkus? Mr. Shimkus, nay. Mr. Pitts? Mr. Pitts, nay. Mrs. Bono-Mack? Mrs. Bono-Mack, nay. Mr. Walden? Mr. Walden, nay. Mr. Terry? Mr. Terry, aye. Mr. Rogers. Mr. Rogers, nay. Mrs. Myrick. Mrs. Myrick, nay. Mr. Sullivan. Mr. Sullivan, nay. Mr. Murphy. Mr. Murphy, nay. Mr. Burgess. Mr. Burgess, nay. Mrs. Blackburn. Mrs. Blackburn, nay. Mr. Bilbray. Mr. Bilbray, nay. Mr. Bass. Mr. Bass, nay. Mr. Gingrey. Mr. Gingrey, nay. Mr. Scalise. Mr. Scalise, nay. Mr. Wada. Mr. Wada, nay. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper, nay. Mr. Lance. Mr. Lance, nay. Mr. Cassidy. Mr. Cassidy, nay. Mr. Guthrie. Mr. Guthrie, nay. Mr. Olson. Mr. Olson, nay. Mr. McKinley. Mr. McKinley, nay. Mr. Gardner. Mr. Gardner, nay. Mr. Pompeo. Mr. Pompeo, nay. Mr. Kinzinger. Mr. Kinzinger, nay. Mr. Griffith. Mr. Griffith, aye. Mr. Waxman. Mr. Waxman, aye. Mr. Dingle. Mr. Markey. Mr. Towns. Mr. Towns, aye. Mr. Pallone. Mr. Pallone, aye. Mr. Rush. Ms. Eshu. Ms. Eshu, aye. Mr. Engel. Mr. Engel, aye. Mr. Green. Mr. Green, aye. Ms. DeGette. Ms. DeGette, aye. Mrs. Capps. Mrs. Capps, aye. Mr. Doyle. Mr. Doyle, aye. Ms. Schakowsky. Ms. Schakowsky, aye. Mr. Gonzalez. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Ross, aye. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Matheson, nay. Mr. Butterfield. Mr. Butterfield, aye. Mr. Barrow. Mr. Barrow, aye. Ms. Matsui. Ms. Matsui, aye. Ms. Christensen. Ms. Christensen, aye. Mr. Upton. Mr. Upton, nay.
The other members wishing to cast a vote, Ms. McMorris Rogers.
Ms. McMorris Rogers, nay.
Other members wishing to cast a vote? If not, the clerk will report the tally. Come back at 1. Come back at 1. Yeah, I didn't. I was talking.
Mr. Upton? 20 ayes, 30 nays.
20 ayes, 30 nays. The amendment is not agreed to. The committee stands in recess until 1 o'clock.